Appeal part heard in the matter of Ras Al Khaimah Investment Authority and Azima and others.
Yes.
Good morning, Lords. So I had been about to turn to the judgment, the Court of Appeal judgment itself, when we closed off yesterday. And as you'll remember, that is in supplementary bundle, March Appeal Supplementary Bundle, tab 11. And just want to get its process and structure straight. So what you see during the introduction, and as we page down, starting on page 3, is that in paragraph 6 to 8, there is a section on the shape of the appeal describing what the different grounds are. And my own friends do fairly point to the fact that in the course of paragraph 8, dealing with the application for permission to adduce fresh evidence, and grounds 6A, 6B, and 8A, you get the summary that the court should find on those grounds that hacking is established, and then in the alternative that there should be a remission, and then it is said, and since the judge's decision that Mr Azima had not proved his hacking allegation was fundamental to at least some of the judge's conclusions on RAKIA's substantive claims, they too should be submitted for retrial, which is the point they make about saying this same case was taken to the Court of Appeal. In the event, as we'll see, the court doesn't really deal with it that way. So it sets out the factual background, and then turning down to paragraph 39, the court expressly sets out its approach to the appeal, which is to take the grounds of appeal in a different order to that in which they were advanced. And that's, as of course you've seen in the oral argument, this is exactly what happened. The first day was taken up in substance with ground 5. But explain that they will nevertheless follow that analysis and first work out whether, well, if there is a case as to hacking, what are its consequences for this case as then presented. And then we get the assumptions that are made for that purpose in paragraph 40. And there's a little bit of debate about how far they go, but they are undoubtedly limited. And paragraph C is that at least some of RAKIA's witnesses gave dishonest evidence about how it came into possession of the hacked material. But that's as far as they go.
That's important, isn't it? Because that demonstrates what the Court of Appeal had in mind was potentially, never mind how many witnesses it was, but they'd been dishonest about how they came into possession of the material.
That and
what
that
they were
only.
Focusing on was dishonesty in relation to matters in the main claim.
Exactly so.
The honesty or credibility of which you would be able to challenge at any retrial in the light
Yes.
of some of the material you showed us yesterday.
Exactly.
Obvious example, the suggestion that the referral agreement was a sham.
Exactly.
But nobody at RAKIA appears to have woken up to the fact that it was a sham.
Yes.
That's
No,
that
indeed.
sort of point.
Indeed, that's exactly right. And I'm going to make that good when we come to paragraph 61 and 62. What it is, it is the Court of Appeal setting up what follows, which is its analysis is that the case as then presented is that the hacking is purely collateral to the claims against Mr Azima. And it is on the grounds that it is collateral that they are able to segment it from the rest of the proceedings. So set that up in 39, then deal sequentially first with the argument based on Jones and Warwick, that is for exclusion of the evidence, that's 40 to 47, and citing the old decisions, Khaimah and the Queen, other such decisions, as to English court's general position that how the evidence came doesn't really matter. What matters is its relevance. And determine that this is not a case in which all of the evidence should be excluded. That's only in a very extreme position that would be done. And then at paragraph 51 through to 65, deal with the Summers and Fairclough jurisdiction. That is to strike out claims as an abuse by virtue of the conduct of the claim itself, of the conduct of the litigation. Summers being one of these cases about presenting a fraudulent case as to how incapacitated someone who was injured really is. And they deal with Summers from 52 to 55. And then at 57 to 59 comes this collateral dishonesty point by reference to the judgment of Lord Sumption in Versluit dredging, which is an insurance case dealing with the requirement that you are honest in your presentation of a claim. And Lord Sumption had made the point that, well, it's one thing if you dishonestly exaggerate a claim in an insurance context, or dishonestly present a claim that isn't there at all, well, of course, there will be a breach of that principle and you will forfeit your entire right to an insurance indemnity. But different, where there is an incidental dishonesty, which does not go to either the principle or the quantum of the relevant insurance claim, and in that event says, well, that principle simply can't apply because it is completely collateral. And at 60 to 62, then brings that into this case. Put another way, any unlawful conduct in obtaining the emails was not central to its underlying claims. Compare a case in which it was central. Insofar as Mr. Page and Mr. Halali, here concentrating only on them, although I accept that paragraph 40 might go further, told lies, they were collateral and lacked centrality in this sense because they did not go to the merits of RAKIA's underlying claims. And therefore then, on that basis, say, you can't strike out in that situation because the dishonesty is collateral. And therefore, the only remedy, going back to the Summers and Fairclough jurisdiction, is interest and costs, which is something expressly identified by Lord Clark in Summers and Fairclough. That's the analysis, completely different to this case. Then paragraph 66 to 70, I referred to yesterday, that's appeals on matters of fact and the importance of the Fage and Shabani principle. From paragraph 71, on page 21, we get ground 7, which was the attack on reliance on the heavy lift representation. And all that is dealt with, as you will see in 71 to 78, is the argument of law that was raised, given the constraints of appeal, which was, well, there's been no evidence from the ruler. The case had to be the case advanced by the ruler. And that's rejected on the legal argument that really what Mr. Buchanan has said and his reliance is enough to make out RAKIA's case for the reasons given in 75, 76, and so on. Now, it's quite right, as Mr. White said yesterday, that the submission by RAKIA, I beg pardon, the submission by Mr. Azima did go further than that. It did say, and going back to paragraph 8, well, the dishonesty ought in effect to undermine the evidence on reliance generally and justify everything being set aside. The Court of Appeal never deal with that, and indeed in paragraph 71, as I showed you yesterday, actually set the debate up on a contrary footing, in the sense that they say, well, the finding that Mr. Buchanan relied on the representation is not challenged. Now, Mr. White sought to explain that away on two grounds. One, that, well, the Court of Appeal don't have to state everything, that's obviously true. But perhaps, he speculated, that was an origin, that was a consequence, I beg your pardon, of the alternative case as to hacking by Cyberroot, which was a post-settlement agreement hack. That's identified by the Court of Appeal, paragraph 134, when we come to hacking. So perhaps that's the reason, because then the argument wouldn't really, that's just idle speculation, with all respect to him. One doesn't know. The fact is simply the Court of Appeal dealt only with the narrow argument relating to the absence of evidence by the ruler. Then 79 onwards turn to the conspiracy claim and deal with the narrow point that the sham allegation was not put to Mr. Adams. And then for all of the reasons that are traversed through to paragraph 118, the Court of Appeal concludes that the principle is one of being apprised of the case that you have to meet, and that witness statements, Mr. Azima's cross-examination, etc., the point was sufficiently communicated, and there was no necessity that specific allegation be put to Mr. Adams, or no reason to upset the finding on the basis that it was not. And dealing in that context also with the new evidence on the conspiracy, which was the witness statement from Mr. Newey, one of the identified buyers. And as you were shown by my learned friends, that was rejected on 3 grounds, both for failure of the reasonable diligence requirement, on the basis, secondly, that Mr. Newey was said potentially not to be independent, and therefore it might not be sufficiently credible evidence or sufficiently powerful evidence. And thirdly, which is the point that they rely on, that it didn't disturb the main pin of the judge's reasoning in regard to the conspiracy. And I'm going to come back to materiality in this context, but as you will appreciate, that was also in the context of an appeal where there is deference on issues of fact to the trial judge, quite different when one is in a application to set aside a judgment on the basis of fraud. And then under 122, conclude that RAKIA's claims, the judgment must stand, it should not be struck out or dismissed, deal with equitable set-off in 123 to 128, and then in 129 and 30, turn to the counterclaim and commencing with fresh evidence on the hacking claim. And Court of Appeal reaches the conclusion that a complete re-evaluation of the evidence is called for, debates the different possibilities, Dale and Banga and so on, and I'll come back to that, before concluding there should be a remittal only of the hacking claim for retrial. Now that is exactly the analysis, subject to the confusion point which I will come to, that is exactly the analysis that the judge worked through when considering the Court of Appeal judgment. And that is at paragraphs 57 to 72 of His Lordship Mr. Justice Michael Green's judgment, which is in Core Bundle tab 10. My friend Mr. White criticised the analysis by the judge of the Court of Appeal judgment for what he called inappropriate compartmentalisation. It wasn't a point he then developed, at least so far as I understood, as to what compartmentalisation there was and why it was inappropriate. What I would suggest is that if what he means by inappropriate compartmentalisation is that the judge worked through the structure of the Court of Appeal's judgment, identifying the parts that are dealing with different grounds of appeal, well, far from it. That is the structure of the judgment and is the right analysis. As to understanding that structure, yesterday at around page 56 of yesterday's transcript, my Lord the Chancellor observed that the entire debate about remission and fresh proceedings, the Dale and Banga debate, was confined to the hacking counterclaim. And with respect, that's exactly right. And one can see that in paragraph 129. Second sentence, we turn then to consider the hacking claim, but only in the context of the counterclaim. And that is the introduction to everything that follows. There really is no doubt about it. Now, as to what the judge was puzzled about.
Well, that's the explanation of paragraph 135. I mean, 129 qualifies everything that follows.
Exactly.
And makes it clear that what they're talking about is the judgment in respect of the hacking counterclaim being affected by fraud.
Exactly.
not anything else. So the judge's puzzlement was, well, one could say he shouldn't have been puzzled.
He shouldn't have been puzzled. Yes, with respect. I entirely agree. That is the point that I was about to come on to. So the judge's puzzlement is expressed in paragraph 67 of his judgment, and is directed at paragraph 134 and 135 of the Court of Appeal's judgment, and asking himself the question as to what fraud was being talked about for these purposes. And paragraph 135 actually records, I beg your pardon, paragraph 67 actually records the answer that I made in submission in the permission application, which was that it's talking about the fraud of the hacking itself. And in my submission, that is entirely clear, and I do agree that the judge's puzzlement was unnecessary. So really that is the Court of Appeal's judgment. Now, the appellant's argument is effectively this, and I can give the references to Dechert's skeleton just for convenience, but it's been developed orally. Their argument is that the argument advanced by Mr Azima in the Court of Appeal included the contention that there had been a massive deception of the court and that the whole case should be remitted. That's the last sentence of paragraph 8 of the Court of Appeal judgment. That the Court of Appeal rejected that submission, that the current case, that is the set-aside claim, is the same case as he was always advancing, even if there is some limited new evidence as to the hacking. That's paragraph 38 of Dechert's skeleton, and that the Court of Appeal cannot have intended that the new evidence of responsibility for hacking might justify reopening the claim. Now, we say that's just not right in a number of respects. I accept that Mr Lord put it high. He argued that both on the original evidence, when properly considered, and a fortiori, when considered together with the new evidence then before the Court of Appeal, the Court of Appeal should find that hacking was established. And that if it found that hacking was established, it should strike out RAKIA's claims. That's the first high-level submission. And the Court of Appeal deals with that in paragraph 140 to 141 and concludes plainly they can't make that decision at appellate level. It would have to go back to be re-established. And then secondly, that he submitted that RAKIA was therefore guilty of a massive deception of the court and everything should be remitted, paragraph 8. But on any reading of the Court of Appeal judgment, it is analysed through the prism of the grounds of appeal. And you were shown the passages in the transcript where, in effect, the grounds are put to Mr Lord. It is true, Mr Tomlinson, in response, said, well, he wouldn't really take a point on the grounds. But you don't see that approach being taken by the Court of Appeal. But more importantly, back to the previous proposition, the core analysis is the collateral lies point. So the Court of Appeal did this because it could say this is a purely collateral lie, and it is a purely collateral lie because it only is dishonesty in and about the obtaining of the evidence which ought to have been disclosed in any event, and therefore does not affect RAKIA's claims. I should just say in passing, the obtaining of the evidence, it's sometimes expressed in different places as if Mr Azima had had an opportunity to disclose everything but had not done so and they then got it by hacking. That's of course not the case. There is no basis to infer that all of these documents that are material to RAKIA's claims, privileged documents aside, would not have been disclosed in the ordinary course if the claim had been brought. RAKIA's point was, well, it wouldn't have known that it had a basis for the claim. We would say, you start to look at the material in the updates. Quite the contrary. Of course it knew it had a basis to litigate different things, if they are valid. So core analysis is the collateral lies point, and all of the statements on which Mr Masefield relied, where the Court of Appeal say judgment on the hacking, on the RAKIA's claims must stand, cannot therefore be understood to mean anything else than that collateral lies are insufficient to establish grounds for exclusion of the evidence, strikeout for abuse of process, equitable estoppel, or the remission of everything. And the entirety of the appeals, this appeal by my learned friend, the appeals by my learned friends, are really constructed on an over-reading of those findings. So the new evidence that we have now, the scope and scale of it has been found to be material by the Deputy Judge. I should perhaps say that I beg your pardon, by His Lordship Mr Justice Green, I should perhaps say that if you have want to have any sense of the strength with which His Lordship Mr Justice Green was persuaded that the evidence is material, you might also have regard to the judgment granting permission to appeal, and in particular to paragraph 27 of that judgment.
Where's that? In the core bundle?
And that is in the core bundle. Sorry, just open up the core bundle. I momentarily mislaid the reference, but I'll give it to you. It is in the core bundle, tab 15, at page 7. I firmly believe that the new evidence is potentially strong enough to establish the sort of pervasive dishonesty around the obtaining of the first judgment, such that it could well have affected the findings that were made in relation to RAKIA's claim against Mr Azima. And therefore the fraud unravels all principle should outweigh the finality principle. But he then grants permission to appeal on the abuse point. Coming back then to, as I've done progressively on a number of occasions, to what has been identified as the core question, which is what did the Court of Appeal mean? It's a matter of objective interpretation of the judgment. My learned friend's case, as logically put, is that the Court of Appeal must have meant any inquiry into those claims is foreclosed forever and a day, regardless of what evidence may turn up in regard to fraud in the obtaining of that judgment. Now, the Court of Appeal, of course, do not say that. It would be an extraordinary conclusion because it would be excluding a jurisdiction that has been recognized as one of the critical safeguards of the finality principle. And I would suggest on that basis cannot possibly be implied. And so my learned friends retreat to a lower proposition, which is to accept, in response to Lord Justice Newey, by Mr Pulbrough yesterday, that, well, if there was a smoking gun, it would be a different matter, or by my learned friend Mr Masefield on the first day in regard to saying, well, if there was qualitatively different evidence of fraud, you just stand back from that. So what they're saying is they accept that the Court of Appeal could not have intended simply to foreclose any further inquiry. And that in appropriate circumstances, an action to set aside the judgment for fraud could be brought. And the question then is, well, what are those circumstances? There is only one jurisprudence that answers that question. And that is the jurisprudence of setting aside claims for fraud as expressed in Takar and as expressed by Lord Justice Aikins in Royal Bank of Scotland and Highland. And therefore, the only questions are fraud condition, so new evidence. Can the fraud condition, is there a real prospect of success of establishing a fraud condition? Answer yes. Is there a real prospect of success of establishing that the new evidence is material? Answer yes. Neither of those things are disputed. QED. Can I, in that context, pick up the Lucas directions point, which was featured much in Mr Masefield's submissions? Mr Masefield took the court to the fact that in argument, you don't find it in the judgment, that in argument there is a point at which Lord Justice Lewison raised the fact that dishonesty about aspects collateral to the main claim could lead to a Lucas direction. And the inference that meant they were considering the possibility, which is why he raised the point, that someone other than Page and Halabi may have lied. And so the some witnesses may have lied must include the obvious inference, Mr Buchanan. Now that's probably correct as far as it goes, of course only in argument, not in the judgment. But can we just dwell on the Lucas principle for a moment? Your Lordships are well aware of it, but for what it's worth, the case is reported, so it's R versus Lucas, 1981, Queen's Bench 720. It concerned the position in criminal proceedings relying for conviction on an accomplice's evidence, and whether there is or is not a requirement then of independent corroboration, and if there is, or insofar as there is, whether that corroboration can be obtained by finding that the accused himself has been dishonest about something, whether that can provide the necessary corroboration. It's all dealt with at page 724 of that judgment. And the essence of the Lucas principle is that you can only take you can only take corroboration from that dishonesty if the accused's lie is deliberate, if it's a lie on a material issue, and if the lie can, as a matter of analysis of the facts, be said to have been motivated by a realization of guilt and fear of the truth. And all of that has to be established independently than in the accomplice's evidence itself, because otherwise you're bootstrapping yourself. And the rationale for that is that people sometimes lie for all sorts of reasons. And what the passage identifying the all sorts of reasons on that page gives the example of, for example, in an attempt to bolster a just cause, or out of shame, or out of a wish to conceal disgraceful behavior from their family. Those are the examples that they give. But all of those observations are preceded by another observation at 724 next to the letter D. Just read it to you. It accords with good sense that a lie told by a defendant about a material issue may show that the liar knew if he told the truth, he would be sealing his fate. This, of course, in the criminal context. So returning to this case and the relevance of all this. The point raised in argument by Lord Justice Lewison was that a limited and collateral lie by, insert in parenthesis Mr Buchanan, would not necessarily justify any inference as to his dishonesty about RAKIA's claims, reliance, etc. And so put, that's obviously right. Because it all depends.
All he's doing is I think you're overcomplicating this with respect.
I may.
What Lord Justice Lewison has in mind is simply that in the context of civil litigation where there is, where a case is made that one party's witnesses are not telling the truth about something, judges effectively self-direct themselves in the same way as the Lucas direction you give to a jury in a criminal trial by asking themselves the question, if X has lied about this, does that mean he's lying about everything? And therefore ask themselves the question, why is he lying? And the point the judge was making there was simply that on the material before the Court of Appeal, the lies were to do with the hacking, which the Court of Appeal regarded as collateral to the main claim.
That's right.
And therefore, merely because let's take Mr Buchanan, merely because Mr Buchanan might have been lying about what he knew about the hacking, doesn't mean he was lying about all the other evidence.
I agree completely.
Known constat that if there's evidence before the court that lying about other things, lying about the main claim, that you would need to give yourself that sort of direction.
Exactly.
So in a sense, it simply demonstrates, at least it seems to me, how the thinking of the Court of Appeal was, well, all we're really dealing with is lies in relation to hacking and not in relation to anything else.
Quite. Thank you, my lord. Your lordship summarised it far better than I was doing in developing. That takes me then to return to the question of materiality. Hopefully not at too great a length, but I'll deal with it insofar as our primary point, of course, remains that materiality is not within the scope of this appeal, and that what my learned friends are attempting to do is to bring it into the scope of this appeal. But nevertheless, on a belt and braces basis, let me just list a number of points insofar as it assists in understanding why the case is rather different now to what it was before. So we start, and I said to you yesterday, I gave you the references to the passages in the pleading, in which we carefully set out the attack on each of the claims and the materiality of the evidence to those claims. But if we start with the heavy lift investment representation, first issue, falsity of the representation. The case depended, in part at least, on whether the value was an agreed value, as Mr Azima said, which represented the value contributed by heavy lift to the joint venture, or whether the representations concerned simply a cash cost to heavy lift, as the judge ultimately found. And you'll see that in, amongst others, paragraph 79, 86 to 9, and 94 to 97 of Deputy Judge Lynn's judgment. The falsity, the conclusion that there was no agreed value was one reached on the basis of negative findings about Mr Azima's credibility and Mr Adams' credibility, which are critical to his reasoning on the issue. And we have pleaded, and there can be no serious doubt about this, that because the new material shows that Mr Azima's case, Mr Adams' case, is corroborated on a material number of points, then of course it must follow that their credibility itself falls to be re-evaluated, and that will lead to a re-evaluation of the falsity of the representation itself. Secondly, reliance. As to reliance, 5 points. Perhaps not the biggest of them, but I'll start with it. I made the point yesterday about the updates showing access to Mr Azima's inner team communications about the bet. I'm sorry, I don't know whether anything can be done about the speaker, but and if it's worrying you, there's some.
I don't know what it is, but it's
coming from behind, from above my head. And as long as your lordships can hear me, I'll just continue.
It's a little distracting. Sounds like somebody's using a photocopier in court. That's why I was looking down there to see if somebody was using a
No, I think it's a microphone that connects to this has been engaged somehow. But I can't say what is to be done about that. It flicked on and off yesterday a little, but only a little.
Anyway, carry on. So reliance.
So reliance, 5 points. First point, smaller point. This issue of the bet inside Mr Azima's team as to how much would ultimately, the claim would ultimately be settled for. And RAKIA relied on those communications to show that, well, that must reflect a position within Mr Azima's team that acknowledged that the claim was being exaggerated. I don't necessarily accept that. But the point is, Mr Buchanan knew that already, because he'd been told about it in the project updates. And that's tab 29 and tab 34 of the supplementary bundle. 29 before the settlement agreement, 34 after the settlement agreement. I showed you those yesterday. So he couldn't then, if that is their case, have believed that the claim was simply for outgoing expenditure and no issue of, as they could put it, exaggeration arose. Bigger point. As we showed you yesterday, the 17th of August update, that's tab 25 in the supplementary bundle, shows that RAKIA had access to Heavy Lift's documents and to its internal accounting and other records. Now, Mr. Macefield said, well, those documents, the balance sheet, it's the one that he referred to, wasn't of any particular use to RAKIA because actually the balance sheet itself does not reflect a cash outlay, nor should it, incidentally. But the point is, again, that Mr. Buchanan's position at trial was that they had no information about Heavy Lift's claim until they obtained the documents from the Torrens in August 2016, and that was self-evidently a lie. Third point, RAKIA's case at trial and Mr. Buchanan's evidence was that the claim was settled and the payment was made because he and RAKIA believed that it was obliged to compensate Heavy Lift. Now, the updates show that what was being bandied about was reasons why RAKIA may have believed otherwise. And you can see those referred to in the re-amended counterclaim at paragraphs 224A and 226A. Now, of course, it's entirely right to say that, well, suspicions doesn't necessarily, the fact that you have suspicions doesn't prevent reliance. But that is to miss what his evidence was. His evidence was, he thought it was a matter of obligation, he had no reason to doubt it, and that was a lie. RAKIA presented its case as being, this is the fourth point, litigation about a commercial settlement. But the whole evaluation of that case now falls to be considered in a different light, because what I've shown you in the updates is that the purpose of the attack on Mr. Azima, starting in August 2015 and continuing without interruption thereafter, was to take Mr. Azima off the playing field. And in particular, you saw that in the August report on the generator at Supplementary Bundle tab 24, the action plan in January 16, Supplementary Bundle tab 30, and further in the 26th of January report, Supplementary Bundle tab 31, and later in April, Supplementary Bundle tab 34, and of course, in that context, the very close monitoring of the privileged communications during the negotiation of the settlement agreement, as shown in Supplementary Bundle tab 29, and in our pleading of 221D, and the idea of a trap. So RAKIA's construct that this is a simple commercial settlement in circumstances in which it was dependent upon Mr. Azima for the information, accepted that it had an obligation and had no reason to doubt what he was presenting, but understood it to be a cash outlay position rather than a value position, and denied that the value attributed to the equipment was an agreed value. All of that plainly comes into question in the light of these documents. Turning to the good faith representation, firstly, there were a number of points taken in regard to it. It was said it's false in regard to the hotel. The facts relating to the hotel were cited by RAKIA as breaches of the good faith representation. And we say, well, the documents corroborate introduction. I'll come back to that in the context of the conspiracy. And it's perfectly plain, call for a reassessment of the credibility of what Mr. Azima and Mr. Adams were saying. Secondly, it was essential to RAKIA's case on the good faith representation that at the time of conclusion of the settlement agreement, it believed that Mr. Azima was acting in good faith and did not know anything about the points later relied on against him. And yet that is plainly false. Amongst those, the proposed 10% interest in the hotel. This is re-amended counterclaim paragraph 210. RAKIA was aware of those proposals by August 2015. That's Supplementary Bundle 26. RAKIA got further information about that company. It was initially called Eurasia Hotel Holdings, later came to be called Eurasia Aviation Holdings. That's Supplementary Bundle tab 31 in January. Another one. relied on in the good faith case is that the commission agreement was a sham and that that was a breach of good faith. But as you saw yesterday, the referral agreement, or at least one of the two drafts in issue, I'll come back to that, was exhibited already to the update report in August 2015 and is obviously material to the question whether the ruler knew about it and had approved it. I should mention in that regard, Mr. Macefield relied on backdating. Backdating was common ground, that it had to be backdated. And the judge then analyzes whether that was being done genuinely or not genuinely. The key question was the agreement concluded prior to the introduction? And did the ruler know about it, as Mr. Azima said he did? Thirdly, other misconduct. My friend Mr. Macefield said, well, the other misconduct referred to in the update reports is not against RAKIA, so it's not relevant. Well, that's just not right. Mr. Buchanan's evidence was that he had no knowledge of any suggestion of misconduct by Mr. Azima before he saw the documents when he got them, he said, in August 2016 from the torrents. And you'll find those passages in the schedule to the claim. I called it yesterday, inadvertently, Schedule 1. It's in fact Schedule B, but no doubt your lordships would have found it. And one can see that the updates include the January one, the suggestion that there may be deceptions and frauds using the client's funds. That's tab is supplementary bundle, tab 30, page 4. The suggestion that sensitive documents relating to heavy lift have been intentionally concealed from Mr. Buchanan. That's supplementary bundle, tab 25, page 1. The suggestion that Mr. Azima had failed to fulfill his obligations under the referral agreement. That is supplementary bundle, tab 26, page 3. The suggestion that in the same report that Mr. Azima had breached RAKIA's confidentiality. So all of those, again, show that Mr. Buchanan, on material issues, was plainly lying. And again, generally, same point about the purpose of all of this, seeking to take Mr. Azima off the playing field. The idea that RAKIA relied on good faith when its real purpose was to take Mr. Azima off the playing field is simply not one that can be credited. And the whole case as to reliance depends on Mr. Buchanan's evidence and the ruler's evidence, and they have been discredited. Lastly, the conspiracy. First point, introduction of the bias. Now supported by innumerable references to the introduction in the updates and supported by what Mr. Al-Sadek has said in the interviews by Mr. Gerrard in the documents that were not disclosed. Mr. Macefield made the point, perfectly fairly, that all of those references, all they could be mistaken, they don't definitively establish introduction. I accept that, but that just isn't the question. The question is whether they are material to the analysis as to whether there was introduction. And we say they plainly are. The introduction of the bias is a specific element of the case on the good faith representation and a specific element of the conspiracy case. And you might see the deputy judge recognizing its importance in paragraph 181.3 in his judgment, that supplementary bundle, tab 1, page 53, and using that to infer that there was a bribe, and I'll come back to that. So, second point. First point, introduction. Second point, sham referral agreement. I said I'd come back to the draft point. I didn't say yesterday, and I don't believe it's actually significant, but it is important, nevertheless, that I make it clear. One of the points in the trial is that there were two drafts of the referral agreement. The signed one is the one that I showed you yesterday, and that is the one which was identified by the investigators, by the hackers, and produced in August 2015. There was then a later version with some changes to the way in which expenses work, sent to RAKIA in October 2012. It's not in these bundles, but that difference is a difference which doesn't, that detail is a detail which doesn't go anywhere. The core point is, what was clear is that throughout 2015 and 2016, as part of the greater investigative project, it was being identified that a referral agreement had been concluded and Mr Azima had an entitlement to 5% commission, and that was never challenged. And the question of how those receiving those reports reacted to that is obviously fundamental. Third point, approval of the commission by the ruler. Deputy Judge found that the commission was not approved, and that was based on accepting the reliability of the ruler's witness statement, the ruler not having appeared for cross-examination. Now, the ruler is now completely discredited. And all of the evidence as to the reference to the referral agreement and its non-challenge in itself shows the very serious counterweight that now lies against his witness statement. Fourth element, the bribe. So when Mr Masefield presents this as if there's incontrovertibly a bribe, well, one really has to think about it. This related to a $500,000 payment admittedly made by Mr Azima to Dr Masad. Mr Azima explained it related to an aircraft, and there was some quite confused evidence about different aircraft and the credibility of that version. And that's analysed in detail in the Deputy Judge's judgment at 184 to 185. But as the judge records in paragraph 186, the really key point of RAKIA's argument in that regard was that there was a receipt of 500,000 for which there was no entitlement. So what leads to the inference it's a bribe? Well, that depends on whether the commission agreement had in fact been reached and whether the ruler had in fact approved the payment of commission. Because if he had, then Mr Azima only received what he ought to have received. Well, indeed, half of what he ought to have received because he agreed to take a discount. So it undoes the entire finding as to the bribe. I did emphasise
well, how does that work? Because the bribe is allegedly paid by Mr Azima to Dr Masad.
And then repaid.
Why does it make any difference if, I mean, you would say this is all for trial, but why does it make any difference that Mr Azima was entitled to the commission? I mean, what's said is this is Mr Azima saying thank you very much to Dr Masad and putting a bung his way, if I can put it that way.
Yes,
that's the argument.
So maybe I didn't explain it clearly enough. In paragraph 186 of Deputy Judge Lennon's judgment, which is Core Bundle tab 10.
Core Bundle tab 10?
Core Bundle tab 10.
It's not, that's Justice Michael Green.
You're entirely right.
Supplementary Bundle.
I'm grateful to my learned friend. Supplementary Bundle tab 1. Paragraph 186 is on page 58.
Yeah.
RAKIA's case that the payment of the $500,000 was a bribe rests essentially on the inference to be drawn from the fact that the payment was made on the date that Mr Azima received a fee authorised by Dr Masad to which he had no entitlement.
Yes. Okay, thank you.
So if he had the entitlement, the proposition collapses. And of course, the debate about the alternative explanation for the money and its later repayment back to Mr Azima, which is in 184 and 185, will all look very different, with different credibility being an issue. So really, materiality was rightly found by the judge to be clearly established to the requisite standard. That takes me to Koshi. I think I can probably do Koshi before the short break, and we'll then just have some concluding submissions after the short break, if that suits. And I can say as a matter of prediction, I will line up about 12:15 as a target, which would give Malone and Friends the 45 minutes that I understand they want for reply, and your lordships will still get lunch.
We'll get lunch anyway, Mr.
Yes. So that takes me to the argument, really the sort of final card, as it were, is the argument based on the decision in Khaimah versus DEG Dechert Investitions. Two judgments, both in the bundle, one in tab 5 of the authorities bundle, and then the Court of Appeal in tab 6. Malone Friends Mr Pilgrim only went to tab 6, the Court of Appeal decision, for logical reasons, and I'll do the same.
The short answer to Khaimah is a case in which he tried to overturn Mr Justice Harman's judgment on the basis of the same evidence over and over again.
Yes, exactly.
The case where there was new evidence.
That's exactly right. Yes, that's exactly right. So that's why it is a completely different case. No new evidence, repeated efforts to run the same argument. An election specifically put to him to rely only on 2 paragraphs of the finding in the merits judgment, which enabled them to set up an argument of misrepresentation at the time of the freezing injunction proceedings, which in turn gave rise to the costs order.
Yeah.
And a finding that actually, an election that the case would be put on that basis and that basis alone, and that case ultimately fails. And then he says, well, now I want to go behind it. And what had happened, of course, when he made the election, is that in substance, he was offered remission. Mr Khaimah was offered remission to say, well, this issue of whether there was a misrepresentation to Mr Justice Harman could go back on a remitted basis. But he didn't want that, because he didn't wanted to deal with it there and then. He thought he had an ace in the hole in these 2 paragraphs of the merits judgment, and he elected to rely on those only. He was given time to confirm that election, and he confirmed it overnight in writing. And the next morning, the consequences of that election were again clarified and debated with the court. The court made clear it might still dismiss his arguments on procedural reasons, not necessarily on the merits. And nevertheless, his counsel elected to continue accepting that clarification. And in the Court of Appeal, Mr Pilbara was right that there are 3 reasons that are given. The one is the election, not election in a legal sense. It's identified all the time as a slightly looser sense of election, but nevertheless it's the election point. The second point being that in fact he was wrong to say that the previous court previous appellate court had not dealt with the point on the merits and had only dismissed his claim on procedural grounds. What's found is that in fact on a proper analysis they had dealt with the merits, so that didn't arise. And then it was said thirdly, abusive process. And so Mr Pilbara presented it, therefore, on the basis that abusive process was an independent, self-standing, self-sufficient reason. And therefore the case is an analogy, even if an extreme one, to which you can have some reference. But with respect, that's just not right. And can we just turn to the Khaimah Court of Appeal decision in tab 6 of the authorities bundle. Turning first to page 24, paragraph 33. And friend Mr Pilbara rightly took you to these introductory paragraphs, that's 33 through to 36 in the conclusion section. And the explanation, there is an issue to consider here, but then a conclusion, in my judgment, the appeal falls to be dismissed on the following 3 grounds, and then list the 3 grounds. And as you'll see, ground 1, the election point, that's paragraphs 37 and following through to 44. Ground 2 at the bottom of page 27, paragraphs 45 through to 52. There was a decision on the merits point. And then ground 3, abusive process. Can we start with 53? Ground 3 is, this arises if this court did not deal with the merits of Mr. Koshy's contention that the order as to costs made by Harmon J should be set aside. So it's a ground that flows out of ground 2 in the way it's there explained. But more importantly, the court then proceeds to analyze whether there was an abusive process. And can we just pick up 56, 58, and 59? And what you will see in those paragraphs, I'm not going to read them to you, what you'll see in those paragraphs is that fundamental to the finding of abusive process was all of the facts relating to the election. So it's actually not distinct from the election point at all. So it therefore, A, is a much more extreme case, quite unlike this one, no new evidence, etc. B, does not sustain the analogy that my learned friend Mr. Pilbrow wishes to take. But he retreated from that to, or progressed from that to a more general point, which is to say that the principle identified under ground 3 is that you only get one opportunity fully to present your case, or you may only get one opportunity fully to present your case. And therefore, if you have had a full opportunity previously to present your case, there may be an abusive process in trying again. And the shortest and most direct answer to that point is to consider the question whether Mr. Azima had a full and proper opportunity to present the case that he now knows he has in the first appeal. And frankly, my submission to the court is that submission is absurd. In the Court of Appeal, he was confined by Fage and Shabani. He had an inferential case. He had some limited new evidence of phishing emails and some second-hand evidence as to a new hacking theory relating to cyber. Nothing like what he has now. The new evidence demonstrates the procurement of the hacking and its cover-up and the deliberate manufacture of perjured evidence for the court beyond peradventure, and includes a raft of material which is directly material to RAKIA's case on its own claims, as to dealings with the hotel, as to his role, as to his alleged secret interest, as to the referral agreement, as to the commission, as to the heavy lift accounts, as to the background to heavy lift. And in our submission, the idea that his previous attempt to use inference to overcome RAKIA and Mr. Buchanan and Mr. Gerrard's massive deception and their mendacious concealment of the truth, the idea that that was an adequate opportunity so as to foreclose any further inquiry really is a travesty. I have some short concluding submissions, but I think probably it would be best if I do them after the short break.
Yeah, okay.
And Malone friends will then be comfortably into play.
We'll break for 5 minutes.
Thank you.
All right. I don't feel like it's so tiring.
This is literally the first time I've ever got it out. About 10 days ago, put it on my desk so that I couldn't forget it, so that I didn't know I'd used it. But he says it's a bit more complex. Sorry, I'm teaching both. The reason for doing it was I may not do it again too often, but
Sort of Billy's boots. It would be.
So, now Roger has assured me,
You get your lunch.
no more than he has assured me, that it's half an hour from him, but less, 10 minutes from Phil, 5 minutes from you. I am holding you to this.
You mentioned
I'm holding you by finishing my lunch. I would be deeply aggrieved.
if we don't,
It'll be your fault.
absolutely will be.
Oh, you won't, we won't last time. Yeah, fine. Actually, I'm prepared to accept that as a sufficient answer to the challenge. Not a big issue. What's that about?
Correct.
Thank you. When I started yesterday, I sought to summarise the case that my learned friends presented, and I said it was really 6 points, and I set them out at the start of the meeting. And without unnecessarily repeating them, I want to go back to those 6 points. So the first point was said to be that Deputy Judge Lennon had considered the evidence of fraud in the underlying liability, as my learned friend Mr Macefield put it, as really indisputable. And coupled with that the new evidence doesn't include anything materially or qualitatively different. And taking those two together, of course, that is the first point, that indisputable suggestion, is the very thing that the set-aside claim seeks to establish is wholly wrong. That far from it, these claims were not well founded. Materiality is, of course, not appealed. We say Deputy Judge Lennon's judgment and his approach to the analysis was procured by this material fraud. Now, Mill and Friends placed in that regard significant weight on the fact that in the judgment, in many respects, Deputy Judge Lennon relied upon documents, some of Mr Azima's documents, and indeed linked to it the analysis of Mr Azima's credibility in regard to what was said in and around those documents. And of course, in the set-aside claim, if it is allowed to proceed, they will raise all of those points. They will seek to say there is enough here. But all of that analysis is plainly, on any reading of the judgment, bound up in the greater picture, including RAKIA's credibility, the credibility of Mr Buchanan, the credibility of Mr Gerrard, the credibility of Birss, the evidence that they did or did not produce, the fact that they did not have documents, which plainly they now have. It really beggars belief that what the appellants come here to say is that, in effect, there is nothing to see here in what RAKIA maintained in the first trial. So those are bad points. Their third point from that was that, well, that is why the Court of Appeal found that the hacking was collateral. Now, of course, entirely right, the Court of Appeal considered that the hacking was collateral. But it considered that it was collateral because it was faced with, essentially, a very limited challenge to the fraud findings. And you saw that being put to Mr Lord in the course of submission. That he couldn't dispute those points on appeal, which was because of the limitations on that appeal. So, if they were just collateral dishonesty, well, that would be one thing. But it is not why they found them to be collateral. That's just what they were faced with. And that in turn, fourth point, is why the Court of Appeal did foreclose any further case, the forever and a day point. And I've made my submissions on that that plainly is not something you can read into the Court of Appeal's judgment. And perhaps Mr Macefield's core point was that this is the fifth one, that Mr Azima fought and lost the arguments as to materiality to RAKIA's claims in the Court of Appeal. That's not materiality in the sense we're presently considering, but that is as to the relevance of the hack to anything else. But we've seen why that was so. We are on entirely different ground now. Insofar as submissions were made, and they were made, that went beyond the grounds and said, well, there is a dishonesty here, there is a deception of the court here, that does not come close to a submission founded on the material that is now before me. And again, His Lordship Mr. Justice Green's finding of materiality is not in this appeal. And so their sixth point is that Mr. Azima's case in the set-aside claim is simply the same as that which was previously advanced and which the Court of Appeal rejected. And really, that's a remarkable proposition. All of the new evidence that he has now, he did not have then. It's a different case. The question is how far that evidence goes. It is material, QED. Miller and friend Mr. White sought to raise an atmospheric point yesterday in this regard, which is he pointed to a passage somewhere in the transcripts of the appeal in which Mr. Lord had said there is plenty of evidence of fraud. True, Mr. Lord did say that. The submission was that there was sufficient evidence before the Court of Appeal, for the Court of Appeal to overturn the finding that the hacking was not established. But that does not mean, and obviously does not mean, that what has now been found is immaterial. It's a noble attempt by my learned friend Mr. White in his professional duty to shield Mr. Buchanan from the inquiry into his dishonesty that is coming and should come, but is really quite simple. So, sit back. What was the issue? The issue is, does Mr. Azima have a real prospect of success of establishing the fraud condition and the materiality condition? Answer, yes. Does that leave space, nevertheless, for an abuse of process finding that notwithstanding him having that case, he should not be allowed to proceed? For all of those reasons, we would say no. And so we would ask you to dismiss this appeal.
Thank you, Mr.
May it please you, my lords. I expect to be about half an hour in reply, and then Mr. Pilbara maybe 10 minutes, Mr. White maybe 5 minutes. That's roughly what we're aiming for, so we hope we'll finish by lunchtime.
Good.
My lords, I opened the appeal by saying that it turned on 3 substantive issues. What did the Court of Appeal mean? And it said that Deputy Judge Lennon's findings of fraud must stand, irrespective of the outcome of the hacking counterclaim. Second, is Mr. Azima now trying, via a different procedural mechanism, to do that which the Court of Appeal said he should not do? And third, has there been a material change in circumstance that might justify that position? And having heard the submissions on both sides on the law, we would submit that those are indeed the 3 important issues in this case. This is unusual litigation, because not only has the fraud issue been ventilated before, it has been pitched very high previously. And despite the fraud allegation having been ventilated before and pitched very high, the Court of Appeal has already determined that the Lennon judgment must stand irrespective of the outcome of the hacking counterclaim. Now, given those unusual facts, it is perhaps not surprising that the outcome in a case like the present is not covered by previous authority, because it is not a case that has been contemplated by previous authorities on abuse of process. That said, we would agree and respectfully adopt my Lord, the Lord Chancellor's observation that if we are right about what the Court of Appeal meant, and if Mr. Azima is trying to do what the Court of Appeal said he shouldn't, to allow him to do it would bring the administration of justice into disrepute, and abuse is made out. Equally, if we are wrong about that, and that's not what the Court of Appeal meant, we would accept that there is no abuse of process. So the first and critical issue on the appeal is, what did the Court of Appeal decide? And on this, your lordships already have my submissions. We say the Court of Appeal could not have been more clear, both in its judgment and the order that it made. The Court of Appeal said the Lennon judgment on RAKIA's claims must stand, irrespective of the outcome of the hacking counterclaim, and that his findings would be binding on the Chancery judge to which the matter was remitted. So a win on the hacking counterclaim would not mean that the Lennon judgment could be set aside. And the Court of Appeal spelled out at paragraph 40 the assumptions it was making in Mr Azima's favour and what a win on the hacking counterclaim might look like. The Court of Appeal said that even if Mr Azima proved at trial, first, that RAKIA was responsible for the hacking, second, that its witnesses had lied about that and had conspired to cover the hacking up, that nonetheless the Lennon judgment that found Mr Azima was a fraudster should stand and there should not be further relitigation about that. Now, not only is that the natural and ordinary reading of what the Court of Appeal judgment says and its order, we say that one can readily understand why the Court of Appeal reached the decision that it did, because it was at pains to spell out its reasoning. In particular, the Court of Appeal identified a number of cogent public policy factors which led to that, and you have my submissions on that. I'm not going to go back through those. So we say, on the first critical issue, the Court of Appeal meant what it said. Now, we do not say that the Court of Appeal was ruling out what might happen if a qualitatively different fraud emerged. I will come back to that. I think there's actually less of a difference than might at first appear between Mr Pluman and myself on this issue. But what it was clearly ruling out was that a win by Mr Azima on the hacking counterclaim would not in and of itself be enough to reopen the findings on RAKIA's claims. So even if Azima could show that RAKIA was responsible, and even if he could show RAKIA's witnesses had lied about their involvement or their knowledge of the hacking and had sought to cover it up, that would not allow him to reopen the judgment of the deputy judge. And in our submission, Mr Pluman has no real answer to that analysis of what the Court of Appeal meant. So too, on the second issue, is Mr Azima now trying to achieve by a different procedural mechanism that which the Court of Appeal has said he should not do? We say that the answer to that question is clearly yes, subject to the material change in circumstance point I'm coming to. And in fairness, Mr Pluman, in neither his written nor his oral submissions, has seriously sought to suggest otherwise. We say it really would be a triumph for form over substance for the court to try to read the earlier Court of Appeal judgment down and to say that it was just concerned with whether evidence should be excluded or that RAKIA's claim should be struck out on the Summers and Fairclough basis. The argument that was advanced on Mr Azima's behalf before the Court of Appeal went much wider than that, as we've seen. Mr Azima had said he had options, that he could start fresh proceedings, or he could raise the issue on the appeal, and try to persuade the court to find that RAKIA was responsible for the hacking and set aside the judgment, which the Court of Appeal declined to do. Alternatively, he asked for the Court of Appeal to remit the matter to a new Chancery judge to consider whether the entire judgment should be set aside, not just the hacking counterclaim, but the judgment in RAKIA's favour too. And that was Mr Lord's submission, which the Court of Appeal records at paragraph 8 of its judgment. But as we've seen, the Court of Appeal was not prepared to accede to that submission. It was prepared to remit the hacking counterclaim, but the hacking counterclaim only. And it said in terms that it favoured remission of the over fresh proceedings precisely because it could structure the remission to ensure that Deputy Judge Leonard's findings on RAKIA's claims should stand and be binding on the Chancery judge. And absent a material change in circumstance, to now allow Mr Azima to bring a claim to set aside the judgment would therefore be to undermine the Court of Appeal's judgment and would constitute a collateral attack on it. And we say there is no real answer to that second issue. And that therefore brings us to the third, and I think probably the most critical issue in the appeal, which is whether there has been a material change in circumstance. Have things now moved on since the Court of Appeal looked at it, which might justify Mr Azima seeking to relitigate the fraud issue? Having already had one go at ventilating the fraud issue before the Court of Appeal, and having pitched it very high, and yet having that argument on fraud rejected. Now, if a smoking gun had emerged in the course of the hacking counterclaim, which went not to the hacking itself, but to the underlying merits of RAKIA's claims against Mr Azima, we would accept that Mr Azima could relitigate the fraud issue, notwithstanding what the Court of Appeal has said. This was my Lord Justice Newey's point, which your Lordship put to me in the course of my submissions, and which I accepted. And there are two reasons we say why that must be the right approach. First, the Court of Appeal has not said anything about that. Whilst the Court of Appeal was at pains to spell out that it was not enough for Mr Azima to establish that RAKIA was responsible for the hacking and that it had lied about it, it did not say anything about what was to happen if a new smoking gun emerged which went to the underlying merits of RAKIA's claims. So it would be over-reading the Court of Appeal's judgment. We accept that to say that it had meant to foreclose us. Second, there is the point made by Lord Sumption in Dechert, albeit obiter, which is that if decisive new evidence emerges that a judgment was procured by fraud, then a party should be able to relitigate the fraud issue, even if it has had one go at it already, because in those circumstances, the court will want to protect the integrity of the justice system, and if there is a smoking gun or decisive evidence that establishes the fraud, then that cannot be ignored. So if Mr Azima could point to a smoking gun in the Project Beach reports that went not to the hacking, but to the underlying merits of RAKIA's claims, we would accept that he could establish a material change in circumstance. But we say that despite Mr Pluman's best efforts, Mr Azima cannot, in fact, do that. I'm going to work through each of the claims briefly to explain that, and in particular why the referral agreement and the references to the referral agreement are not a trump card for Mr Azima.
I think the difficulty you've got is that you haven't appealed the materiality conclusion that the judge made. Because, I mean, what's said against you is that what Lord Sumption was talking about was effectively the test in Highland. In other words, he says, well, you'll be fully protected by Highland in this situation if you've argued it previously and you're not trying to reopen it. If you satisfy the two Highland conditions, then there won't be an abusive process. That's effectively what you're saying.
Two points in response to that, my lord. Yeah. The first is that the word Sumption uses in Dechert is decisive, and we say he means what he says.
Well, he says it in one paragraph, he says on the next one.
And the next paragraph he goes on to talk about the Highland test.
Yeah.
But he's talking about it in the context where there's already been one go at having fraud set aside. And the point is, you need, if you're going to have another go, the original conditions that you could have the first time round may not be enough. You may need to have to point to something higher. It may need to be decisive. It may need to be a smoking gun. And particularly when you've already had one go at it, you've pitched it very high. The second point, and
just before you go on, just to try to understand what the Court of Appeal was dealing with. It had evidence that there had been hacking. How far was the Court of Appeal having raised before it what had been discovered through the hacking? Was that relied on in any real way?
No, my lord. I mean, it was said that reliance was overplayed by Mr Buchanan because if he had already had access to all the hacked material, it would follow that his credibility was called into question generally, and reliance in particular would be called into. So that was in play, but beyond that, things weren't developed.
So broadly, there's evidence that you have lied about the hacking.
Yes.
And that goes to credibility. And building on that, a wider assertion that there may not have been reliance. But the Court of Appeal wasn't really concerned at all with what had been discovered in the hacking.
Correct, my lord. I accept that.
And why wouldn't that be a material change of circumstance if you find something significant in what had been discovered through the hacking?
Because it has to be significant. What I will come on to, and I hope make good in a moment, is that actually when you look at the Project Beach reports, there is nothing significant in that sense.
But
but just-
that again, I
Yeah.
mean, I repeat the point I just made. That it seems to me at least to trample on the materiality condition, because that's exactly what Lord Justice Aikins says you're trying to find out.
My Lord, I was halfway through answering my Lord's question. If I can complete my answer. So the
Yeah,
first
sorry.
point was, when you've already had one go at it, it needs to be decisive before
That's
you
what
can
you
have a go at it. That's our first submission.
That's what you
The
said.
second is, we have accepted materiality because were it not for what had previously been argued in front of the Court of Appeal, we could see that there would be an argument that because of the hacking and because of the availability of the hack material, that could infect the claim. So prima facie, there is a prima facie case of materiality we would accept, but for what the Court of Appeal has already ordered.
Mr. Messer, why is the point you made that there's a higher level, higher threshold, a decisive threshold open to you if you didn't appeal the materiality? Isn't that submission a submission that the wrong legal test was applied on the materiality condition?
My Lord, no, with respect, because what is open to us is the abuse of process point, and we say the materiality issue has already been determined by the Court of Appeal, because if the material simply goes no further than corroborating a case on hacking, and that our witnesses may have lied about it, the Court of Appeal has already considered that and said the judgment must still stand. So prima facie, we would accept, were it not for that, that those issues could be said to be material and could be used to set aside a judgment. And therefore, there is no challenge to that materiality element. What there is a challenge to is abuse of process. And in that context, we are entitled to say, well, you say things have moved on from the hacking case that you ran before, but actually, hang on, no, they haven't. The court can't shut its eyes to what the Project Beach material does or does not show.
The difficulty with this argument, leave aside the point that my Lord's just put to you, which is I think we're both putting very well in the same points, is it goes back in a sense to Mr. White's point about compartmentalisation. You try to compartmentalise what Lord Sumption says in TACAR in 66 and 67. Somehow dealing with two different things, but they're not. He's dealing with the same point. He having said if there were decisive new evidence you could set aside even if you run fraud previously, unless you deliberately chosen not to investigate, for example. He then says, I recognise there's a risk of effectively an abuse of process. However, there are these stringent conditions in Highland, and he then says, which he agrees with the rest of the court, that that's enough to effectively to avoid abuse. And then the last sentence of 67, I do not think that the imposition of further conditions will be consistent with the long-standing policy of equity and reversing transactions procured by fraud. Now that sentence is clearly saying you don't in this example where you previously alleged fraud, so that's the only situation in which the whole concept of abuse of process would be of any relevance. He's saying it would be wrong to impose any conditions other than the two Highland conditions. Now, why isn't that? I'm assuming that what Lord Sumption says is binding on us, or at least is sufficient
Of persuasive value.
probative
my
value.
Lord,
We should rely on it. Why
that-
doesn't that answer the point?
That is one reading of what Sumption says, obiter and takar. I accept that. Another reading is that when he says decisive, he means decisive. If you've already had one go at it, you shouldn't have another. And the bull point, my Lord, is not, we would submit that legal test, because we say when you actually look what's come forward in the Project Beach reports, there is no impact on the underlying merits, apart from the general points that have already previously been advanced, that it goes to credibility and reliance, but those points were advanced, and the Court of Appeal has said those aren't enough in and of themselves.
Can I just test how far you go?
Yes.
I mean, I follow credibility, then you put
Yes.
in reliance.
Yes.
Suppose there's no smoking gun in the Project Beach reports, but there is material that could usefully be put in cross-examination, either on reliance or on something else. And that plainly was not before the Court of Appeal. Is that significant for your purposes?
My lord, we would say no. We would say it doesn't have sufficient weight to allow the party, where it's already had one go at the fraud case and has put it as high as it was put here, it's not enough to say there might be something in this. It's time to have re-litigation. We say that's not a high enough hurdle.
Yeah.
But in any event, when one actually looks at the different claims, as I'm about to do, we say there isn't the material there to support my learned friend's arguments. When you actually look at what the Project Beach reports say, and it's important for me to do that in a little bit of detail. The court has my points that if, at a general level, of course, Mr. Azima says the Project Beach reports provide powerful support for Mr. Azima's case on the hacking, that RAKIA was responsible for the hacking and that its witnesses were involved in it or knew about it and lied about it to the court. But those generic points, the Court of Appeal has already said, in and of themselves, are not good enough. So the question is, does the material in the Project Beach report go further than that? Can we start with the heavy lift misrepresentation claim? And Mr. Pluman seeks to argue, by reference to the Project Beach reports, that Mr. Azima can now demonstrate that RAKIA in fact had access to the heavy lift financial information, which showed Mr. Azima's representations to be false, and therefore it could not have relied on Mr. Azima's representations about heavy lift.
He says that they had access to the information itself. That's a lie that he says was told by witnesses at trial, that they didn't have access to the information, irrespective of the falsity or not of the information.
What Mr. Buchanan said is he had no way of verifying what was in the reports. So they had some of these materials because some of these materials were communications that were sent to RAKIA's former CEO, Mr. Stewart, by Mr. Azima in the course of preparing his claim from heavy lift. So it was never anybody's case that RAKIA had no materials.
No, it wasn't the point, but the point is that what Mr. Buchanan was saying is he had nothing that made him, as it were, supported the heavy lift claim as it was presented, and therefore no, as I understand it, no basis for supposing that what Mr. Khaimah was telling them wasn't correct.
Exactly.
And yet what now emerges is a completely different picture. Crawling all over everything to do with Mr. Azima and saying, well, this man is not to be trusted.
It's that second point, my lord, that it doesn't go that far because...
Well, it may not go that far, but that's all a matter for trial.
Well, one needs to look at the...
One thing, there has to be a reality check here, to be honest. Which is, we have to ask ourselves, because unfortunately we're not the same Court of Appeal that said it last time. It might be an argument it should have been before the same Court of Appeal, but it hasn't been put that way. And nobody's asked for it, I don't think. What would Lord Justice Lewis and his colleagues have thought if they had seen the material that we have seen now? Would they still have said, well, never mind all that, you're shut out from arguing anything to do with the main fraud claim against you, and that will stand for all time? And speaking for myself, I think it's inconceivable that's what they would have said.
My lord, just to your
by
first...
all means try and persuade us otherwise.
Just to your point there, we did actually ask for the same Court of Appeal.
Did you? Sorry.
My learned friend Mr. Pluman said, no, we want a different court.
That's not right. We actually thought that was a matter for the court to decide for itself and said nothing.
And I think Lord Justice Lewison said it should definitely be a different court.
Did he? I haven't asked anybody about it. We were just we were only doing what we were told to do.
But just so my lord understands, we had actually thought it would help make it a slightly faster process. But
it is a slightly odd position to be asked.
Can we just look on the heavy lift misrep?
Yeah, sure.
At the Project Beach report, which Mr. Pluman relies on primarily for this, which is at tab 25 of the supplemental bundle.
Sorry, just a second. Tab 25.
go for, and it's tab 25, and it's pages 1 and 9 and 13 of this report. And at page 1 and page 9, you can see the author of the report referring to having obtained access to memo, balance sheet, and FA's supporting documents. One sees that on page 1, and that's at item 6 on that page. And if we move forward to page 9, you can see that there is, sorry, I think it's 9 in the internal numbering. Yeah, sorry, it is that page. The second paragraph, we've discovered confidential files prepared by Heavy Lift regarding the matter, including confidential memos, balance sheets, and other supporting FA documents. Just pausing there, if one drops down to 4, item 4, which is itemised there, items 3 and 4, there's the balance sheet, which we're about to come on to. There's the Academy Director's report, and then there's the letter to RAKIA's former CEO, Jim Stewart, emails and financial data sheet. So these were documents, certainly that letter to the former CEO, Jim Stewart, that RAKIA already had, quite legitimately. So there's no difference that if it's got it through this hacked data. And when you actually look at the balance sheet, which Mr. Pluman didn't take you to, it's at page 13.
Yeah, well, you showed us this.
This is the balance sheet, which in fact contains references to Heavy Lift investing $1.7 million in the simulator and spending $450,000 on the training aids. Now, it was only at the trial, my lord, having heard the evidence of Mr. Azima and Mr. Adams, when the documents were put under a forensic microscope, that the judge concluded that those entries were false and did not fairly reflect the true position. Mr. Azima, the judge found, had in fact paid only $167,000 for the flight simulator and had not provided additional consideration, although he maintained, even in the face of the hacked material at trial, that he had. And it was conceded by Mr. Adams that nothing had been spent on training aids and that the entry that one sees was false. The reference for that, my lord, is paragraph 111 of the Lennon judgment, MASB tab 1, page 23. And it is notable that even in the face of all the hacked materials which RAKIA disclosed, Mr. Azima continued to try to say that he had not misrepresented the position and that the values in the balance sheet were justifiable. And the materials relied upon by RAKIA and the judge to decide that the balance sheet were false are not referred to anywhere in the Project Beach reports or the documents relied upon Mr. Pluman. And in short, in our submission, Mr. Pluman cannot point to anything in the Project Beach materials which shows that RAKIA knew that Mr. Azima's claims about the heavy lift investment were false. If anything, the documents that he points to would have caused RAKIA to believe the falsity of what was being represented and would have beguiled it further. And it was only established at trial that these entries were false. So we say there is actually nothing in the Project Beach materials to displace the conclusions on the heavy lift misrepresentation. The same, my lord, is true of the good faith misrepresentation. I can take this a bit more shortly. And the first point to note is that Mr. Azima tries to advance a slightly schizophrenic case here. On the one hand, Mr. Azima says, I did nothing wrong. I'm not a fraudster, and Deputy Judge Lennon was wrong to say that I was. But at the same time, Mr. Azima comes before the court and says, RAKIA knew before it entered into the settlement agreement that I had backed it in bad faith, that I had defrauded it, and therefore the settlement agreement was a trap. Now, Mr. Azima clearly cannot have it both ways. Either he accepts that he was a fraudster, in which case he can try to run the trap argument, or he disputes that he was a fraudster. And in fact, it's clear that it's the latter that he really contends for. He denies that he ever defrauded RAKIA. And he says it's therefore very hard for him to argue that RAKIA had firm evidence of his fraud before it entered into the settlement agreement. And again, despite listening carefully to Mr. Pluman's submissions yesterday as he took you through the Project Beach materials, he did not take you to anything in the Project Beach reports in which the author says it is clear beyond peradventure that Mr. Azima has defrauded RAKIA. There are passages in the Project Beach reports, which I took your lordship to, and Mr. Pluman also went to, where the author says there is some evidence of potential criminal activity. But those passages are always couched in tentative terms, and the crimes that are identified, breach of US sanctions law, breach of the US Patriots Act, breach of Azeri anti-bribery laws, would not have been actionable by RAKIA. And there is nothing in the reports, with great respect to my learned friend, that shows that RAKIA knew, before it entered into the settlement agreement, that Mr. Azima had acted in bad faith towards RAKIA. That was only established at trial. Now, it was suggested in this connection that Mr. Buchanan had lied about this. Mr. Pluman, in his submissions this morning, said Mr. Buchanan claimed not to have any knowledge of Mr. Azima's wrongdoing. But with great respect to my learned friend, that was not, it never was Mr. Buchanan's evidence at trial. If we turn to the Deputy Judge's judgment, it's page 79 behind tab 1 in the supplemental bundle. Supplemental bundle, MASB, tab 1, page 79, paragraph 243.4. The Deputy Judge quotes from Mr. Buchanan's witness statement, so the court can see 243.4, my lord.
243. Yep.
And the judge says this is consistent with the evidence of Mr. Buchanan, who was responsible for the signing of the agreement. He explains in his witness statement that prior to the execution of the settlement agreement, I was aware of allegations having been made against Mr. Azima and concerns expressed about his conduct. However, had I known what I now know insofar as concerns Mr. Azima's wrongdoings, there's no way I would have recommended. And what the Project Beach reports show is that Mr. Buchanan was being truthful in that regard. He did know that allegations had been made against Mr. Azima and that concerns had been expressed about his conduct. And he had actually disclosed the project update report that remained in his possession, which made that good. And RAKIA had disclosed the view from the window document. So we say that actually there is nothing further in the Project Beach material that shows that there was a deception of Judge Lennon in this respect.
Can I just ask one thing about this, which I'll probably get muddled on?
I doubt it, my lord.
The materials we've got now suggest that RAKIA knew about the bet at the time that the agreement was being negotiated. And that rather suggests that they knew that what they were going to offer was going to be more than the other side thought they were going to get.
The Project Beach reports show that they knew there had been a bet because they find a reference talking about who has won the bet. They don't know what the terms were, and you could have a bet saying, you know, we're in negotiation. I'm hoping to get more than 2.5 million. If I succeed, I win the bet. Let's have a sweepstakes. There isn't. It's not in and of itself an absolutely obvious this whole thing stinks type of point. That's reading it too high. I don't have the reference to the report, but I have looked at it in the past.
Yeah.
My lord should go back to it.
I can't remember.
But
Perhaps we've got it somewhere.
You certainly know after the event that the bet has been won.
bets have been placed. But
You know beforehand that there is a bet, but you say, well, knowing that there is a bet is not the
it's
same
not
as
on
knowing the terms.
because it's an uncertain outcome. What
It's
you would
tab
achieve.
34, page the 20th of
My
April
lord,
26.
we've all had experience, or maybe not all of us, but some of us in practice have laid bets on the outcomes of litigation and what will happen as a consequence. It's not because there is any skullduggery involved, it's because there's uncertainty in the litigation process. And likewise in negotiations, it doesn't, just because you know that a bet has been placed on whether you're going to manage to get them to pay you 2.6 million rather than 2.2 million, doesn't in and of itself show that they're necessarily advancing a fraudulent claim.
Yeah.
That we would say is putting it much too high. If I could then just turn to the third and final cause of action, which is unlawful means conspiracy. Now, so far as the unlawful means conspiracy is concerned, we also say that Mr Azima can't point to any smoking gun in the Project Beach reports that would go to the substantive merits of RAKIA's claims against Mr Azima. And there's a particular point about the referral agreement, which I know has troubled the Chancellor and maybe other members of the court. I'm going to come good to that to show why actually it's a bad point. But can I just take it in turns? So originally, in the skeleton argument for the appeal, Mr Azima sought to suggest that the Project Beach reports included clear evidence that Mr Azima had in fact introduced buyers to the hotel transaction. And that point was not, he maintained it, but he didn't take it very far by Mr Plume in the course of his oral submissions. And we say for good reason. First, because as I showed your lordships, the Project Beach reports don't in fact go that far. They say that whilst Azima was heavily involved in the hotel transaction and that he masterminded, it doesn't say in terms that he introduced it. And the second answer to it, as I showed my lords in my original submissions, I won't go back through it, is that the Court of Appeal has already ruled against Mr Azima on precisely this point when they rejected Mr Naebi's evidence because it was the third strand of rejecting. They said even if Mr Naebi was right and Mr Azima had introduced the buyers to the hotel transaction, that would not have mattered because there were a whole host of other independent reasons why the judge found the agreement was a sham. So instead, in the course of his oral submissions, Mr Pluman sought to focus on a rather different point, and it's one that I gather may have gained some traction with the court. And his point was this: he says, when you look at the Project Beach reports, it's clear that they make references to the referral agreement. But what one doesn't see in 2015 and 2016, when RAKIA receives the Project Beach reports, is Mr Buchannan or anyone else at RAKIA saying, hang on a moment, the referral agreement's a sham. Now, that argument with respect is bad for a number of reasons. I just want to make those good. The first point to note, my lords, is that Mr Buchannan only took over as the chief executive of RAKIA in September 2014, and the hotel transaction was concluded back in 2011, and the referral agreement drawn up in 2012. And Mr Buchannan did not therefore have any first-hand knowledge of the referral agreement, which was purportedly entered into by RAKIA and Azima back in 2011. The CEO of RAKIA at the time that the referral agreement was entered into was Dr. Massad, and it was Dr. Massad who would have had first-hand knowledge of whether the referral agreement was or was not a sham. But as the court knows, RAKIA had fallen out with Dr. Massad, and he was no longer cooperating with them, and indeed he was found to have been a co-conspirator of Mr Azima's in this hotel transaction. So even if they had approached him, they would have unlikely to have got a true story. The second and critical point to note, my lords, is that when RAKIA originally launched its claim against Mr Azima in September 2016, its pleaded case reflected RAKIA's understanding, even as late as September 2016, that the referral agreement was genuine. One sees that. I'm not sure whether your lordships have got access to the original trial bundles, but if the operator can bring up its bundle, it's the trial bundle set of bundles, bundle A, tab 2, pages 9 to 10. I don't know whether that can come up on the screen or not. I'm grateful. And so this is the particulars of claim from the original action which have been amended. One can see the amendments marked on this in red. And towards the bottom of page 9, you've got particulars of Mr Azima's misconduct. Now, the claim as originally pleaded in relation to the referral agreement, one sees struck through bribe secret commissions connected with the sale of the Sheraton Meaty Palace Hotel. And that's then amended, one sees, to the sham referral agreement. And if you look on at page 10, you can see that as originally pleaded at paragraph 8.2, RAKIA had pleaded that it had entered into a contract with Mr Azima entitled a master referral agreement. So originally it was pleaded as a genuine document, but the plea was one that it had been procured by bribery, with the 500,000 being paid to Dr. Massad. And it was only in the course of the proceedings that RAKIA suspected that the referral agreement might in fact be a sham. And what happened was that in October 2017, so a year after the proceedings had started, but some time before the matter came on for trial, that RAKIA's solicitors, stewards, wrote to Mr Azima's solicitors, Burlington's, notifying them of the same, and that was shortly followed by a repleaded case, which one sees here, which alleged for the first time that the referral agreement was a sham. The reference for the correspondence for the court is the October hearing bundle, tab 32, page 79. It's a 4-page letter from RAKIA's solicitors in October 2017, noting that in the course of their review of the documents, it has become apparent that the referral agreement was a sham. Now, it follows in our submission that Mr Pluman's gotcha moment with reference to the referral agreement in the Project Beach report is misplaced. No one said when they saw the referral agreement, hang on, it's a complete sham, because at the time that they received the Project Beach reports, RAKIA didn't know or even suspect that it was a sham. That was entirely consistent with RAKIA's pleaded case, which only evolved to plead that the agreement was sham in the summer, in 2017. And obviously, and importantly, everyone at trial, including the deputy judge, knew that RAKIA had not originally pleaded or appreciated that the referral agreement was a sham, because RAKIA had originally pleaded its case on the basis that it was a genuine agreement.
Well, the plea that's deleted is the plea about the secret commissions, that if the referral agreement was genuine, on the basis it was genuine, there were secret commissions.
Correct.
And that's what is the subject of ground 9 of the appeal.
Exactly, and the court said actually we're not going to defend because that's only an alternative finding, it's all hypothetical.
Yeah, okay.
So there was no fraud being practiced on Deputy Judge Lennon by RAKIA. RAKIA hadn't tried to say we always knew that this was a sham and have always said it was a sham. On the contrary, it was obvious they hadn't said that. And the third and most fundamental point for the court to note is we say, on any view, the referral agreement plainly is a sham for the reasons that the deputy judge gave and that the Court of Appeal soundly reinforced on the appeal. The referral agreement purports to be dated 25th of October 2011, but even on Mr Azima's case, it was drawn up well after Mr Azima had received the payment of the referral fee, so the date is misleading. The key terms of the referral agreement were also thoroughly misleading, as found by the judge and by the Court of Appeal, and the judge found they hadn't been agreed between Mr Azima and RAKIA. Clause 2.1 of the referral agreement provided that Mr Azima was entitled to 5% for his fees. But on Mr Azima's case, and we saw this when we went through the deputy judge's judgment, he was never entitled to a fee of 5%. In Mr Azima's case, he was originally entitled to 5% plus 10% of anything above 50 million for the hotel. And it was his case that that was then revised down to just 2.5% with no intermediate 5% position. So at no point was the figure that one sees in the referral agreement genuinely an agreement between himself and RAKIA. The referral agreement also referred to Mr Azima being entitled to recharge expenses, but Mr Adams accepted in cross-examination that that had never been agreed between the parties. One sees that in the Lennon judgment, paragraph 181.4 in the supplemental bundle, tab 1, page 53. So it's clear that in a number of respects, the document did not reflect a true agreement between the parties. It also referred to the wrong entities. I've made that point earlier. And in short, it was misleading in a number of very material respects. The submission from RAKIA, which found favour with the judge, was that it was obviously an attempt, and not a very good one, to create a false paper trail to try to justify the 1.5 million that Mr Azima had already received, $500,000 of which he immediately paid on to Dr Massad. And as the deputy judge found, Mr Azima's case that he was originally promised $10 million out of a $60 million transaction was implausible. And it was his case that despite having fully performed his bargain, he then agreed to forego most of that and take just 1.5 million by way of commission. The judge said that was also implausible. The Court of Appeal agreed with him. And the whole process by which the referral agreement came to be created, with drafts being sent to Mr Al-Sadek's private Gmail address, asking if they should also be sent to his official RAKIA address, showed, as the judge found, that the authors of the drafts wanted to keep them secret for RAKIA, and there was no explanation put forward that could possibly say why that should have been so. And the fourth point to note, my lords, is that in finding that the referral agreement was a sham, both the deputy judge and the Court of Appeal were strongly influenced by the fact that Dr Massad was paid $500,000 out of the proceeds. Now, Mr Azima seeks to argue that the finding that the money was a bribe rests on the referral agreement being a sham. But in our submission, he has it back to front. When you look at the judge's judgment, which we have in Supplemental Bundle 1, page 53, paragraph 182, the deputy judge starts his whole analysis on the bribery issue by noting that the bribery allegation forms part of RAKIA's case, that the referral agreement was a sham. Sorry, if we can bring up MASB 1, I'm grateful, page 53, 182 in the judge's judgment.
Yeah.
The bribery allegation forms part of RAKIA's case that the referral agreement was a sham. So it follows that the judge is assessing whether the payment of a bribe, in order to determine if the referral agreement was a sham, rather than relying on his conclusions that the referral agreement was a sham to determine if the payment was a bribe. And Deputy Judge Lennon then finds that it was a bribe paid to Dr Massad in connection with the hotel transaction, essentially for two reasons. And you see them summarised at paragraph 187 in the judge's judgment, at page 58, if we turn on the bundle, after he's summarised the parties' arguments. And the two critical reasons that go home with the judge is first because it was paid, the money was paid by Mr Azima to Dr Massad immediately out of the 1.5 million proceeds. In other words, the usual fraud question, follow the money. Who gets to benefit from the transaction? Well, 500,000.
Sorry, which paragraph is that?
It's 187, my lord. Sorry, I've given the wrong reference. Sorry, 186. Payment was made on the date he received the fee, so he followed the money. Same day, and from the same money. And the absence of a convincing alternative explanation. And your lordship will recall what the explanation was. It was an entirely bogus explanation for the reasons that Judge found. Mr Azima claimed he was trying to buy a 25% stake in an aircraft, which just simply didn't stand up to scrutiny because Dr Massad clearly had no interest in the aircraft at all and had never purported to sell it to Mr Azima, and all the contemporaneous correspondence was completely inconsistent with there having been any aircraft transaction. And so having found that explanation was false, and there being no other explanation for the payment, the judge was entitled to draw the inference that the payment was a bribe and to use that conclusion to reinforce his finding that the referral agreement was a sham. And not only that, the Court of Appeal has already said that he was quite right to do so. If we turn to the Court of Appeal's judgment, which we have in tab 11, page 23, paragraphs 80 and 81, page 23 within the tab, I'm grateful. The Court of Appeal sets out the reasons why the judge found that the referral agreement was a sham, and we've run through them already. And at 81, in addition to the 4 identified in 80, there's the reference to the payment of the bribe, and from the fact that Mr Al-Sadek was involved in the retrospective drafting of the referral agreement. And then if we turn on to page 116, when the court, paragraph 116, sorry, which is a few pages on. I'm great. One more page, please.
116.
116. The Court of Appeal says Mr Nayabi's evidence, that's the evidence about whether he was introduced by Mr Azima, doesn't touch upon the judge's main reasons for finding that the unlawful means conspiracy was proved, namely his finding that Dr Mossad received a bribe out of the illicit payments. It doesn't therefore go to undermine the judge's central findings of fact. So we say, when you actually look at it and engage with the material, there is nothing in the Project Beach reports that Mr Blumen can point to which actually calls into question the judge's finding that the referral agreement was a sham. It was clearly drawn up after the event. It clearly did not reflect the true agreement between the parties. Mr Azima's case as to the scale of his remuneration and how it changed was wholly implausible. The process by which it was drawn up is deeply suspicious, and Dr Mossad clearly received $500,000 out of the transaction for a bogus explanation. And in short, we would say, as the Court of Appeal has already held, the judge's conclusion that the referral agreement was a sham was based on a very large number of factors which were overwhelming. And the fact that the author of the Project Beach report was unaware of those factors, which only emerged in the course of the trial, and it therefore took time for RAKIA to work out that it was a sham, doesn't undermine that conclusion. It was always clear to the learned judge from the pleadings that RAKIA hadn't originally realised that the referral agreement was a sham because it had pleaded that it was genuine. So actually the Project Beach reports don't reveal any fraud being practised on the learned judge on that issue. So standing back, my lords, we say that although Mr Blumen would like, by reference to the Project Beach reports, to say that Mr Azima now has a qualitatively different case of fraud to the case that was run before, he cannot do so. We say there isn't any smoking gun or decisive evidence in the Project Beach reports which would allow him to have another go at setting aside the Lennon judgment for fraud. All he can point to is evidence that emerged in the course of his hacking counterclaim, which he say that corroborates his case that RAKIA was responsible for the hacking and had lied about it to the court. But the Court of Appeal has already said that that is not good enough, and that even if Mr Azima establishes that position at trial, the judgment of the deputy judge must stand. But beyond that point, there isn't anything in the Project Beach reports which go further and show a separate fraud by RAKIA on the trial judge relating to the underlying claims. And in those circumstances, we say there is no material change in circumstance which would justify Mr Azima doing what the Court of Appeal has said he must not do. And for that reason, we say his application to amend to bring the set-aside counterclaims is an abuse and should not be allowed. My lords, unless I can help the court further, those were my submissions.
My lords, briefly, in reply on the law, which we've established is not the main attraction here, but so I'll keep it brief. My lord, it was said I had wrongly suggested that my learned friend misquoted Lord Sumption. What I'd actually said was that the proposition for which my learned friend contended in his skeleton, paragraph 57.1, was A, not established, and B, not even an accurate statement. And it turns out I was right on both points. It's not established, it's now common ground that they're obiter, so my learned friend's point that it was established as dispositive doesn't work. And as for B, it's not even an accurate statement. Well, it wasn't, but it turns out that's because it was not the proposition for which they were contending. It was a paraphrase of it, and I should have not taken my learned friend's skeleton at face value, so I won't make that mistake again. Mr Blumen says, well, they're obiter dicta, but they're obiter dicta in which the majority concurred. And that's right, but one does have in Dakar two contrary, mutually inconsistent set of obiter dicta in which the majority has agreed with both. So there's only so far one can take that. as for what I contend is the correct position, I maintain my submission that Lord Kerr's slightly more accommodating approach is to be preferred. And some mockery was made of my complaint about the wording used by Lord Kerr. Someone must remember to tell him, Mr Plewman quipped. And of course there is some force, but also, as I'll show, some irony in the notion that I might suggest that a Justice of the Supreme Court used the wrong word. But consider the point. Lord Kerr was dealing with two situations. One, he was dealing with a case when a fraud case had been raised before, and two, he was dealing with when a fraud case chosen not to be investigated. And he concluded in those situations that it is at least not a given that a party can raise that same fraud case to seek to set aside a judgment. Now, both of those scenarios, a case that was raised before and a case that should have been raised before, are obviously scenarios engaging the abuse of process principle, and to which an abuse of process analysis will be relevant. And given that, it is something of an oddity that Lord Kerr used the word discretion when the authorities are clear that in connection with abuse, one is not dealing with a discretion, one is dealing with a evaluative judgment. See Lord Diplock and Hunter, all the way through to the cases about the test one applies on appeal, Harbour Castle and all of those cases. So I do say that it is an oddity that Lord Kerr used this word, and it may, I suggest, respectfully suggest, show that Lord Kerr was not squarely focused in the appeal before him on an issue that wasn't in the appeal before him, but is relevant to us. So I say Lord Kerr's analysis is to be preferred, but in connection with Lord Sumption's analysis, attention was drawn to my questioning of what was meant by the word decisive, and that is a point picked up again this morning by my Lord the Chancellor with Mr Masefield. And I would add just this point. The argument being run is that when Lord Sumption said, wrote, decisive, what he meant was material. Now, of all the people that one might accuse of having not said what they meant or having not used the right word, I would respectfully suggest Lord Sumption is quite near the bottom of the list. On the contrary, we would say, if he meant material, he would have said material, and since he said decisive, he meant decisive, such that he should be taken to be importing some different and necessarily higher test, as Mr Masefield says, the smoking gun point. Now, fraud unravels all. My learned friend addressed that from within TACAR, making use of the section in Lord Kerr's judgment under the heading, is fraud a thing apart, does it unravel all? And I accepted originally, and I continue to accept, that generally allegations of fraud procuring a judgment, or indeed fraud procuring a transaction, arise in situations where the fraud is new and comes to light after the event. Hence it does unravel all. And so, for example, in the words of Canada and Grantile case that my learned friend picked up in Lord Kerr's exposition, where fraud is present, finality will give way to the responsibility of the court to protect its process so as to ensure that litigants do not profit from their improper conduct. Absolutely, that is what is generally the situation. But with respect, all this tells you is that the usual cases, as summarised there, are a world away from the present case. They're the world away from a case in which A, the fraud in question has been raised before, here we say before the Court of Appeal and the Supreme Court. So just to start with, we're in a situation in which Lord Kerr's discretion is engaged. They're a world away from a case in which the judgment in question is one which established the fraud, or at least the dishonest conduct, the distinction between fraud and actionable fraud that my Lord Justice Newey noted, at least the dishonest conduct of Mr Azima on the basis of the documents and his and Mr Adams's evidence. And whatever, I would respectfully submit, whatever the judge may have thought of, say, Mr Buchanan, that would not have made Mr Azima's explanations of his own conduct on his own documents any better. And C, it's a world away from a case in which the Court of Appeal has already said on a true analysis of what it said, and also understand what we say the true analysis is, you cannot and must not do this. So we say this is a case in which the finality principle and the fraud principle are in tension, quite peculiarly in tension. And therefore, it is a case in which the answer as to which trumps the other, whether the fraud principle is always a trump card, is very much less obvious than the ordinary cases that one sees this discussion taking place in. We say this is a case in which the finality principle should and must trump. And we say it's very much the kind of case in which a court might have reached the view, aware, A, of the relitigation involved in sending this all to be set aside and relitigated, the consumption of public resources involved in all of that, aware of the factual situation, the findings made on one side, as to Mr Azima, and the allegations of a massive fraud on the other, having made assumptions as to the establishment of the massive fraud and the massive deception. A court might well have reached the view, well, a plague on all your houses, we are going once and for all to draw a line, and this is where it is. And we're going to draw that line there, irrespective of the outcome of the hacking counterclaim. Now, obviously, your lordships know, I don't just say this is the sort of case in which that might have happened. I say this is a case in which that is precisely what has happened. That is what the Court of Appeal did and reached that view. And that is why I say Mr Azima is seeking to do what he's been told he can't do. Very briefly, abuse of process and double vexation. Let's take that in stages. Double vexation is an important principle. Clearly, it is one of the two interests underlying the principle of finality, the private one sitting alongside the public one. It may even be the more common of the two in the sense that it comes up more often.
But no, I mean, I think you accepted yesterday. It was yesterday, maybe it was Monday, Tuesday rather. Which day of the week is it? We're in sort of Bairstow, Norris territory, aren't we?
We are, my lord. I'll pick up the Bairstow point exactly.
We're not in the territory where your clients are being vexed second time round.
That's absolutely right. We're not in the case where the additional defendants are being vexed twice, and I acknowledge that. But I do say my learned friend didn't answer or even attempt to answer the second point I had on under this heading, which engaged with the facts of this case, which was to say, well, RAKIA is being vexed twice. They may not be complaining about it, but they are having brought against them the same case, we say, that they have already seen off. And there is plainly a public interest in avoiding the double vexation of a party, even if, for good reason or bad, that double vexed party is not complaining about it. Even if one thinks that the fact that the double vexed party is not complaining means the private interest is not being made out, the public interest plainly is. The public interest against double vexation, the public interest against allowing the Court of Appeal's prohibition to be flouted, and the public interest in ensuring that the court's resources are not used to do this all again.
Is that really something the court should worry about? Is it not for the person who is being double vexed to complain of being double vexed? Why should the court independently, if the person being double vexed isn't complaining about it, worry about that?
Because that there is a public interest in finality. And so if the same point is being relitigated, there is a public interest in ensuring that that doesn't happen. Now, obviously, the person being double vexed usually complains about it, but that doesn't mean that one can still use the court's resources to do again that which has been done once before. Now, as you say, my lord, I'm very happy to see this through the...
I mean, I suppose you could say that there's an issue, there is a public policy issue, or a public interest issue, in the sense that whether RAKIA participate or not, or whether they complain or not, on Mr Pluman's case, that a court is going to be troubled for however many weeks it is, running over the same material again, which means that somebody else's case will be delayed.
Absolutely.
When there are finite resources.
And that is, the public interest.
CPR point.
I do say that, my lord, and I'm very happy to view that through the judgment of Sir Andrew Morritt in the Bairstow case, I entirely happy to do that, and I endorse that, and I congratulate my learned friend, or more likely his industrious and diligent juniors, for establishing that my lord had cited it twice with approval and drawing that to your attention. So they go top of the class for SMARM points. But when one's not dealing with the same parties, one needs either the private interest, the manifest unfairness of the party, or the public interest, and bringing administration of justice into dispute. And we say relitigating this, or permitting this relitigation, would bring the administration of justice into disrepute for the reasons I've identified: flouting the Court of Appeal's prohibition, thereby relitigating or collaterally attacking the Court of Appeal's existing plague on all your houses judgment, inappropriate use of court resources, double vexation of a party, even if they're not complaining about it. The final point, my lord, is Koshi. My learned friend did the very sensible thing of taking this point last, so you have less time to think about the points in reply rather than dealing with it with the law. My learned friend sought to analyse the judgment to establish that I was wrong to suggest that ground 3 was an independent, freestanding or self-sufficient ground. And he sought to do that by pointing out that when the court did its analysis of abusive process, it took into account the facts of the case, including the fact of the election, voluntary acceptance. Now, the fact that, when undertaking its analysis of the abusive process point, the court took into account the facts of the case before it, simply tells us about the nature of the analysis that the abusive process jurisprudence requires. It does not tell us whether or not, analytically, conceptually, this is a freestanding, independent ground. And with respect, I say it makes clear that it is, as I have submitted, an independent and freestanding ground, and accordingly is of relevance to our situation, and it does therefore stand for the proposition Lady Justice Arden set out, namely that justice requires only one effective opportunity to present a case. And my learned friend sought to challenge that on the facts of this case. Has that taken place? And Mr Macefield has been over that material, and I'm not going to repeat that. My lords, unless I could assist any further, those were my points on the...
Thank you very much, Mr. Palmer. Mr. White.
Your Lords, I'm just going to add 2 short points. Yesterday afternoon, when going through the Court of Appeal judgment and the components of it, Mr Pluman made a point under the heading Appeals on Fact. And you remember he said we were putting undue emphasis on the point that Mr Azima confirmed, when pressed hard by Lord Justice Mayles and Lord Justice Lewison, that there was no challenge in the appeal to the findings of fraudulent conduct on his behalf. Now, the way he put it yesterday afternoon in my submission comes dangerously close to saying that the Court of Appeal ought to have struck a different balance. The fact that Mr Azima did not challenge the findings of fraudulent conduct was undoubtedly, in our submission, a component of the Court of Appeal's approach to whether RAKIA's judgment against Mr Azima should be remitted on the grounds it had been obtained by fraud. You see that from paragraph 7 of the Court of Appeal judgment, where they introduce a reference to there was virtually no challenge to the underlying facts of the underlying claims. And then again, when they consider reliance, they make the point that there was no challenge to the fact a dishonest misrepresentation had been made, but rather as to whether it had been relied on.
Yeah.
And my lord, you see it again when they identify the public interests in not allowing the remission of RAKIA's judgment against Mr Azima. They are saying he would be left with the fruits of his fraud. Now, Mr Pluman may feel bruised by that approach that the Court of Appeal took, but the question for this court isn't whether that was right or harsh, but what it meant and what the effect of the conclusion it came to in relation to not remitting RAKIA's judgment on the ground it was obtained by fraud is on the permitted relitigation. My lord,
Can I just, I understand the point you're making, but what is a litigant to do if he has lost a case and he doesn't agree with factual findings that are made in the court, but knows that the only basis on which he could purport to appeal it is a basis the Court of Appeal won't accept, which is the phage point. So should they have had a whole lot of extra grounds of appeal which they knew were never going to get permission to say, we don't agree with this and this and this, but we know we're not going to get permission for it. So you see what I'm putting to?
I do, my lord. I'm not being critical of my learned friends, and
I'm just trying to understand how the point works.
well, the way they sought to get round that limitation was to say, we've got enough evidence, plenty of evidence, that there was a fraud practiced on the court. It would have gone to overall assessment of credibility, and it would have gone to reliance, because they knew about my misconduct before they signed the settlement agreement, taking one particular point of reliance. Therefore, you should allow me to reopen all of it. And the Court of Appeal took a view. And they tried again in the Supreme Court to say the Court of Appeal wrongly took the view that we could only reopen the hacking counterclaim. What should have been remitted were RAKIA's claims against me and my defences to them. And if you look at the application for permission to appeal in the Supreme Court, in the passage I think Mr Maysfield took you to, Mr Azima said the issues in the appeal to the Supreme Court will include whether RAKIA's claims and my defences to them should also have been remitted. So he did have an avenue, he just lost on it. Now, my lord, the second point I want to make is about TACAR.
Yeah.
It's very important in our respectful submission to realise that in TACAR, first of all, there had been no fraud case run at the original trial.
Yeah.
The discussion in Lord Kerr's judgment and in Lord Sumption's judgment is about the approach of the court where there has been fraud run at the original trial and then an application to set aside on the grounds that fraud is made. We've got an intervening stage, haven't we? The intervening stage in this case is Mr Azima ran fraud at trial. He then ran it in the Court of Appeal on the basis that the whole judgment, including RAKIA's judgment against him, should be set aside for fraud. He's now running it a third time. That's the difference between TACAR and the present case. And that's why, even reading Lord Sumption's observations in the way my Lord the Chancellor has suggested, doesn't answer the question, because when you have already raised set aside for fraud and had the Court of Appeal circumscribe it, you've got to show a material change of circumstance. It's the usual test where you're seeking to have another run. At that point you've lost. And that's why Mr Maysfield in our submission is right to say you do need to engage with what is in the Project Beach reports and the extent to which they impacted on.
I don't think that with respect, that I don't think the court was suggesting anything different. But the point that I was putting was the point that the materiality condition derived from Khaimah is effectively the same point. Because if you look at what Lord Justice Aiken says at paragraph 106 about materiality, it is the same as Lord Sumption's point about decisive evidence. It is the same as the material change of circumstance. In other words, there's fresh evidence that wasn't available previously, which gives rise to a material change of circumstance. And it's material because it will lead to a decisive conclusion to the contrary of what the court, or it could lead to a decisive conclusion to the contrary of what the court decided first time round. And that's what he actually says, that it must be shown that fresh evidence would have entirely changed the way in which the first court approached and came to its decision. Well, what's that if it's not decisive?
Well, my lord, the point I'm seeking to make is where you have the intervening stage you have
I understand
here.
that point. I understand
Yes.
that.
We strongly suggest that
And there's an abusive process. There's an abusive process issue that arises here
yes,
that wasn't being contemplated by their lordships in TACAR.
precisely so. They're considering a two-stage exercise.
Mm.
You're looking at a three-stage exercise,
Yeah, understood.
and a three-stage exercise in which the Court of Appeal in the second stage set limits.
Does it really make a difference? Because question is framed by reference to what has changed since the Court of Appeal. And you can map Lord Carr or Lord Sumption onto that question, can't you?
My Lord, it may be that it reduces the same question, but I'm concerned to emphasise that neither Lord Carr or Lord Sumption had in mind this intervening stage with a structural circumscribing of anticipated relitigation. It is a different situation. Lord, unless I can help further, and with, I think, a minute and 3/4 to spare.
Thank you very much, Mr. White. Right, well, unsurprisingly, you may think we're not going to deliver an exemplary judgment at 2 o'clock. We will reserve our judgments, and you will receive them in a draft judgment in due course, draft judgments in due course for any typographical and similar errors, but not for inviting the court to reconsider its decision. Please pay appropriate attention to the embargo at the beginning of the judgment, in terms of not ensuring that contempts of court are not committed. And if you can agree a draft order between you, so that it's not necessary for the court to rule on that. But if it is, we will deal with it on paper.
Lord, may I raise one point just to prevent having to raise it when all of that happens? We have previously sought permission on the embargo as to previous judgments to share the judgment with the US lawyers who also act for Mr Azima in the connected litigation in the US. And I wonder if I can raise now whether that would be permissible in the usual way. The legal team, in other words, includes the US lawyers. It's by no means critical,
yes,
but
provided they
Or subject to-
provided that they give a written undertaking that they've read and understand the embargo and
Yes,
they
of
will
course.
abide by it.
yes, of course. Thank you.
Yes, I think so. Yeah. It only remains for us to thank all counsel and solicitors involved in the case for the presentation of the appeal. It raises some interesting and difficult issues which have been extremely well argued, whoever wins. Thank you all very much indeed.
All rise.